Thank you so much for making the time in your busy schedules to be here, and this is a real treat. Obviously, before us right now is a culture in law. We are debating one of the biggest issues of our time, and to have the experts with us debating these questions is quite exciting, especially in such a historic venue such as this. It really brings sort of America to life in a lot of ways, and so I'm going to introduce to you our moderator, and this is Bob Barnes. He has been a Washington Post reporter and editor since 1987. He joined the paper to cover Maryland politics and has served in various editing positions, including metropolitan editor and national political editor. He has covered the Supreme Court since November 2006. And what his bio does not tell you is that Bob is a nationally recognized Supreme Court reporter who does great work, and it's really an honor and a privilege to have him here. So if we can just
Thank you very much, and it is very nice to be here. This case it has gotten incredible attention, not surprisingly. I could spend all of my time going to briefings about this case because there are so many people putting them on right now. But I will have to say that you guys lucked out at this one because you have a really talented panel here. And I consider my job just sort of getting them going. I think there's one non-lawyer, but believe me, he likes to argue just as much as any other lawyer I've ever met. So I don't think we'll have any trouble getting them going. They're going to make some opening statements, and then I'm going to ask them a couple of questions. And then we'll open it up and have you ask some questions as well. I don't know that we've got a completely representative audience on this question in America, so from time to time I might play devil's advocate or ask you to think about a question that even if you agree with one side, you don't think that that side has done a great job explaining. So let me quickly introduce you to the panelists. I'm not going to go through their whole bio because you have it somewhere in front of you, I think. But Austin Nimitz is with Alliance Defending Freedom. He joined in 2007. I ran into him when he was defending Virginia's marriage amendment in the Fourth Circuit case Bostic v. Schaefer. That was one of the early 2-to-1 decisions by an appeals court that found Virginia's laws unconstitutional. He was also part of the legal team that defended the California marriage amendment in the Prop 8 case and the lawsuit Perry v. Brown, which had a bit of a fizzle once it got to the Supreme Court. He earned his JD from Baylor University. Next to him is Ryan Anderson, our non-lawyer, but PhD, who researches and writes about marriage and religious liberty. He is the William E. Simon Senior Research Fellow at the Heritage Foundation and also co-author of the book, What is Marriage, Man and Woman, a Defense? Justice Alito cited that work twice in his dissenting opinion in United States v. Windsor. He has a BA from Princeton and a PhD from Notre Dame, and you may be familiar with him because he's somewhat famous for being profiled on the front page of the Washington Post not long ago. Roberta Robbie Kaplan was on the winning side in United States v. Windsor. She is a litigator at Paul Weiss, selected as one of the 100 most influential lawyers and top 40 under 40 lawyers in the United States.
That was a few years ago.
Was it? I wasn't going to say anything. There are no questions that you can ask Robbie that she hasn't already received from the Supreme Court, probably. So I would imagine she is just about ready for anything. And you're writing a book.
Yes.
About the experience. That's
Yes.
great. Looking
Coming out
forward
in October.
Great.
Let's hope.
And Also, we have Steve Sanders. And I have the wrong page here, but I'm going to tell you all about him in just a minute. He's from Indiana University. He's one of those people that I haven't met before, but I have quoted before, which happens to me. He's written extensively about the issue of same-sex marriage. And he has written a law review that's often cited called The Constitutional Right to Keep Your Same-Sex Marriage. He received his JD from the University of Michigan Law School. So what we're going to do is have an opening statement for about 5 minutes from each one of these folks. Did we decide on a order, or do I get to choose that? Do you? Okay. Robbie, Austin, Steve, Ryan. I got it. Okay. So Robbie is going to talk. As I told them earlier, I'm going to give them about 5 minutes, and here's a subtle thing I learned about moderating panels. I'm going to stand up when they're almost close to the end of their time, so they can keep talking, but you will all know that they have exceeded their time limit. So, Robbie, why don't you set us off, please?
I'm going to begin with a brief apology, everyone. I have a terrible cold, and so my voice is not as strong as it normally is. I may sound a little bit like Justice Ginsburg tonight, because she speaks very softly as well. Other than our gender and our religion, that's probably the only other thing we have in common. But I'll try to speak into the microphone so you can hear me. Because of the state statutes and constitutional amendments that ban marriages between gay couples, many thousands of gay couples across this country are being treated as second-class citizens simply because of who they are. Marriage obviously affects practically every sphere of day-to-day life, from the old adage of death and taxes, to children and benefits, to status and dignity. Justice Kennedy made clear in Windsor that one of the main problems with the Defense of Marriage Act was that it humiliated tens of thousands of children now being raised by same-sex couples. The exact same thing is true here, but you don't have to take my word for it. Grace, the then 4-year-old daughter of my clients in the Mississippi marriage case, Josie and Carla, begged her mothers to get married so that they would be like other families. The Supreme Court made it clear in Windsor that gay people have dignity under the law that is equal to the dignity of everyone else. And once you accept that equal dignity, any purported justification for the government to treat gay people differently in terms of marriage is unconstitutional, no matter what type of scrutiny applies. Now, let me be clear. It is not necessary to demonstrate overt hatred in order to show an constitutionally impermissible motive in this context. In both Romer and Windsor, the Supreme Court found such an impermissible motive to be present without finding that the citizens of Colorado who voted for Amendment 2 or the members of Congress who voted for DOMA were bigoted. The court in Windsor made no attempt to track the vote of each representative and senator who voted for DOMA. In Windsor, it was enough for Justice Kennedy that DOMA was called the Defense of Marriage Act, that it imposed broad and undifferentiated liabilities on a class of people, and that one line in the legislative history cited to moral disapproval of gay people, a constitutional no-no. There is at least as much evidence here in regard to the statutes currently being challenged. In fact, 2 of those statutes are called the Defense of Marriage Act. So now let me look at the rationales that are being offered. There's really only 2. The first has to do with procreation, and the second is a group of rationales having to do with caution. The argument on procreation that the states make is that the marriage bans are okay because they are structured to incentivize responsible procreative behavior by opposite-sex couples and interests not implicated by non-procreative same-sex relationships. What that means, in simple terms, is that only a straight couple can the woman get accidentally pregnant, and because you want to encourage that woman to get married, and I agree with that, then it's okay to limit marriage only to straight couples. But even under the rational basis test, there has to be both a constitutionally permissible objective and a rational connection between that objective and the means chosen to achieve it. When it comes to procreation, I agree that that's a constitutionally permissible objective. We all agree that being good for children and families is a good thing and an important governmental objective. That's a large part of the reason why gay people want to get married in the first place. But the problem with the procreative rationale is that there's an absence of any connection between that objective and what these laws actually do, which is to exclude gay couples and their children from all the benefits of marriage. While marriage obviously has something to do with having kids, the state's argument is that all that matters is the act of procreation itself and its immediate aftermath. What the states surely also care about, and what our government surely also cares about, is not only how children come into this world, but what happens to them after they get here. The states have offered not a single reason why the children of gay parents should be treated so much worse than the children of straight parents. It certainly isn't their fault that their parents are gay. And just like children who are adopted, there is no possible explanation that passes any test of logic, of common sense, or of simple human decency for why the state should not want these children to have the same benefits as all other children. Moreover, clearly there's no incentivizing that happens here. It's pure fantasy to assume that a teenage woman who accidentally gets pregnant is going to decide to marry her boyfriend because my clients can't. Moreover, that post hoc justification is also nonsensical because it hypothesizes that the only reason why the states issue marriage licenses to straight couples is to channel procreation. But if that were the case, why is there not a single word about it in any of the legislative history for any of the statutes currently at issue? And moreover, if procreative behavior was the only purpose of marriage, then men and women would not be able to marry or remarry for the first time over the age of 55. After all, that would save the states a lot of money in terms of pensions, retirement benefits, and it wouldn't create any privacy issue because everyone has to list their age on the license to begin with. Finally, the law is nonsensical in that it does nothing to ensure that married couples with children actually stay married. If a state wanted to give tax credits or cash bonuses to married couples who stay together until the children grow up, that would be a very different case. But that's not the case, and there are no penalties in these states with respect to those issues, and there's certainly no penalties issued when couples divorce. Let me now turn to the caution rationales.
Wait, I'm going to stop you. I'll let you get back to
Sure.
it, though. Okay? Austin, you were up.
Thank you very much, Bob. I appreciate the introductions and you willing to moderate this debate. I think it's oftentimes difficult when we talk about Supreme Court cases to remember that behind each case are living, breathing human beings that have a real life story to tell. And these stories matter and they're important and the things we should consider. We might mention tonight, we've already heard the Windsor case. And it's easy for us lawyers to throw around case names like they were picked off of a spinning wheel or something like that. But behind that case is the story of a woman named Edith Windsor that Ms. Kaplan very ably represented before the Supreme Court. She shared with us tonight a bit of the story of Grace in Mississippi, and I'm very glad she did that because Grace's story matters. When individuals are pitted against governments in litigation, it's hard sometimes to find the human story behind the facade of the Attorney General and the state defending all of its laws. But even in the marriage cases behind all that, there is a real life human story on the side that is defending the marriage laws. Remember when I was a public defender, oftentimes the hard thing about a prosecutor was to put a face to the victimization and the injustice. You always have a human being and the defendant sitting there, but finding the other side amidst the government was a challenge. It is there. Let's not forget that there are real stories. So tonight I'd like to share with you the story of a woman by the name of Heather Barwick. Heather is one of many children in our society that was raised in a same-sex household. And she chose to share her story specifically with the Supreme Court in an amicus brief about these cases. And her story goes like this. I was raised by my biological mother and her same-sex partner. I have only a few fuzzy memories of my father. A phone call here and there, his deep and unfamiliar voice wishing me a happy birthday, and a dim picture of the way the furniture had been arranged in his house. I have less than a handful of pictures of him. My mom and dad were married for a short time, but she left him when I was too young to remember. She always knew she was gay, and she wanted a chance to be happy with someone she really loved, with a woman. I was raised in an area that was pretty liberal, open and accepting of gays and lesbians. I know my mother experienced pain at the hands of others because of her sexuality, but as a child of same-sex parents, I was never mistreated because of it. I had two loving mothers who cared for nearly my every need, and with whom I have many wonderful and sweet memories. There was one need, however, that they could never meet, no matter how much they loved me: the need for a father. The pain in my life did not stem from the fact that the state did not recognize the relationship between my two moms. It stemmed from the turmoil of desperately wanting a father. I love my mom deeply, fiercely, and unconditionally. She is an incredible woman, but I also love my absent father. I love a man that I don't even know, a man who, by all accounts, is a lousy father. I don't know why I love him. I just do. I ached for my father to love me. I ached for the father I knew I would never have. Do I wish that my mom lived a miserable life married to a man she didn't love? No. I want my mom to be happy. But I also wish that she and my dad did love each other and that somehow it could have worked out. Two loving moms or two dads can never replace a lost parent. Accepting and promoting same-sex parenting guarantees that a child will miss out on a mother or a father. Growing up and even into my 20s, I supported and advocated for gay marriage. It's only with some time and distance from my childhood that I'm able to reflect on my experience and recognize the long-term consequences that same-sex parenting had on me. And it's only now, as I watch my children loving and being loved by their father each day, that I can see the beauty and wisdom in traditional marriage and parenting. So with that story from Heather, let me pose this rhetorical question. Is her story and perspective inherently irrational? Are her emotions invalid or wrong? I can't imagine a single person in this room answering yes to either of those questions, any more than we would answer yes to the emotions and the perspective of somebody else involved in this debate. And because of that, it follows that there are at least two sides to this debate. There are at least two perspectives that need to be acknowledged and given dignity. But what does that have to do with the Supreme Court? The question before the Supreme Court is not whether same-sex marriage is a good idea. It's who gets to decide. That we must keep in mind as we go forward. It's about who, not what. Put another way, do you, every member of this audience, get a voice in this debate? You're here tonight, so I assume you value your own opinion. But notwithstanding how strongly we feel about this issue, do we have enough respect for the opinions of those that disagree with us to honor those opinions and make sure they play out in the forum in this country where we have made for them to play out, and that's in the legislative forum? Or do 9 justices get to sit as a super legislature for all of us? That is the quintessential question before the Supreme Court. As we move forward tonight, I'm hopeful that my esteemed opponents will meaningfully engage this question of who and not what, and explain why they believe, as I believe they're espousing, that every person in this room, as well as Heather, should not get a voice in this debate. Thank you.
All right, thank you, Austin. Steve?
I want to thank Carrie in the Alliance and our friends on the other side. They've been wonderful hosts and for doing this and for having us here. So Austin's organization claims to be about defending freedom, and Ryan's organization claims to be about limited government and individual freedom. Yet here they both are arguing against individual freedom. Their argument is that under our Constitution, gay couples in these cases must surmount the highest possible legal barriers, and states need put forth only the flimsiest and most fanciful rationales in order to keep banning marriage equality, indeed to keep breaking up intact legal existing same-sex marriages. The arguments against marriage equality purport to be about democracy, going slow, responsible procreation, but let's not kid ourselves. They are really about how much longer a shrinking minority of states may continue treating gays and lesbians as second-class citizens based on passions that were whipped up in referenda 5 and 10 and 20 years ago. The state's bans on recognition of existing marriages, the second issue the court has asked to be brief, represent a unique cruelty. It's government power at its most coercive. Once legal family bonds are formed and children and property are involved, the idea a state would purport to invade an existing marriage and unilaterally declare it to be dissolved should be abhorrent, both as a matter of law and as a matter of basic human decency. The only way to defend these laws is to ignore the actual human consequences they have, and to subscribe to a belief that the state should be virtually all-powerful in its ability to dictate our lives, and that human consequences are just collateral damage. And to speak to human consequences for every Heather out there that Austin talked about very eloquently, there are tens, hundreds, thousands of children in foster care awaiting adoption. There are currently 400,000 children in foster care, 101,000 parentless children currently awaiting adoption. As tragic as you may think the personal circumstances of Heather's situation is, why would you want to deny a loving two-parent family to any of those children if that is all that was possible for them? Under our Constitution, we're not bound by rigid, outdated understandings of people's rights or the meaning of social institutions like marriage. If I could transport us back 150 years ago, we would be debating whether marriage inherently means that all of a woman's legal rights are subsumed under those of her husband. That principle seemed as obvious and as divinely ordained back then as the purely conjugal understanding of marriage that our friends on the other side tonight, that it does to them. But our Constitution addresses its timeless principles, its majestic generalities, as more than one justice has called them, of liberty and equality, to the world as it actually is today. Then it measures any exclusion from the government-provided benefits of marriage against these constitutional guarantees of equality and liberty, and it requires the government to justify this exclusion. Who gets to decide? Well, in the absence of any objective harm, individuals get to decide, not the government. It's as simple as that. We cannot sensibly explain how the Constitution should constrain us, under what circumstances, and how it should liberate us, without taking into account the realities of the society we actually live in today. Ryan, in many of his very good writings, has reminded us that law shapes culture. Well, it's actually a back and forth. Culture also shapes law. The great expositor of the common law, Oliver Wendell Holmes, reminded us that the life of the law is experience. The law embodies, he said, the story of the nation's development through many centuries. Our friends on the other side claim in their writings and their briefing to be guided by the lived experience of marriage. Well, for about 20 years now, Americans have been intensely debating same-sex unions. And the result, a solid majority of Americans have now concluded, based on the evidence of their own senses and intellects, that gays and lesbians are capable of fulfilling society's collective, evolving, real-world, lived experience of marriage. People living today, not at the time of Aristotle or St. Paul or Thomas Aquinas or Blackstone, know what marriage is and should be from their own lived experience. They know what makes a good marriage and a bad marriage, who models admirable marital behavior and who doesn't. They should not be forced to cede their own experience and judgment in favor of post hoc rationalizations concocted for purposes of litigation like responsible procreation or abstruse religious philosophizing about how the Constitution must fetishize the mysteries of one flesh and men and women. It is surely honorable now to live one's life according to religious dictates, and it's quaint to be willing to be governed in one's own life by the dead hand of the past, but neither of these things are proper bases for law, and they should not be forced on other people by the government coercively. Our friends on the other side of the table, on the other side of the dais, I'm afraid, have already lost the social and the cultural debate on this issue. And it's for those reasons, because culture shapes law, that I'm fairly confident that they will be losing the legal question as well when this issue is decided next week.
Thank you, Steve. Ryan?
Great, thank you. Thank you all for coming. Thank you for moderating this debate, Bob. And I think all three of the presentations so far tonight have been wonderful. They show precisely the values that are at stake, the lives that are at stake, and the good arguments on both sides of this debate. I don't think anyone can say that their side has all of the good reasons and the other side has no good reasons. No one could say, at least no one could say credibly, that the other side is simply arguing in fantasy land, that the other side is simply making ad hoc post-facto rationalizations. I think everyone could see it. There are good arguments on both sides of this debate, and that our Constitution doesn't take sides in this debate. It's correct that the law shapes our culture, and then our culture shapes our law. That happens through the democratic process. People go to the ballot boxes. They consider the story that Austin told us of Heather Barwick. They consider the arguments that our opponents tonight have made, and then they get to decide what is the lived experience of marriage and what should it be in our state? What should our state marriage law be? They can look to what Aristotle and Plato said. I don't think there's any reason to discount the wisdom of the ancient Greek and Roman philosophers. I think they have a lot to teach us as well, so we're not stuck in the tyranny of our present moment. I think we should look to the voices of children of gay and lesbian couples on both sides of this debate, the stories that Austin have told and the stories that Robbie has told. And then we get to decide as a people, what should marriage be? Because the question before the Supreme Court is not whether my preferred marriage policy is the best, but only whether it's allowed by the Constitution. It's not whether government-recognized same-sex marriage is good or bad, but only whether it's required by the Constitution. So our opponents tonight have to prove that the marriage policy that has existed in the United States throughout our entire history, up until a decade ago, that marriage is the union of male and female, is somehow prohibited by our Constitution. But the only way our opponents can argue this is to adopt a view of marriage that sees it as essentially a genderless institution, and then declare that the Constitution requires their vision of marriage. Simply appealing to the Equal Protection Clause isn't enough. To have the Supreme Court strike down these democratically enacted marriage laws, our opponents have to claim that this vision of marriage is simply false, that there are no good reasons that could support it, and that our Constitution requires an entirely new understanding of marriage. But our Constitution is silent on what marriage is and what purposes the states should devise marriage policy to serve. There are good policy arguments on both sides of this debate. There are good policy arguments to say marriage is just about consenting adult love and caregiving, irrespective of the genders of the party. There are good arguments that say marriage is inherently a gendered institution that unites a man and a woman as husband and wife, so that any children that result from that union have a mother and a father. Good arguments on both sides. Constitution is silent. And so in our constitutional regime, that question resolves by the people and their elected representatives. So as Austin suggested, this isn't a debate about what marriage is. It's a debate about who gets to decide what marriage is. My co-authors and I, we've made philosophical arguments for why we think marriage is the union of a man and a woman, but we wouldn't want the judges to say that every state has to adopt our preferred definition of marriage. We don't think the Constitution requires our definition of marriage. We simply think it allows our definition of marriage. Likewise, I don't think the Constitution prohibits same-sex marriage. I don't think it requires same-sex marriage. I think it allows same-sex marriage. And the question of what marriage should be is one that we, the people, have to decide. And we decide it in the vote that matters most, the vote at the ballot box. And so as law shapes culture and culture shapes law, all of these voices, all of these arguments should be heard, considered, reflected upon, and then we, the people, should vote. Thank you.
Great. Thank you both very much. I thought maybe we need just a quick summary of where things stand at the Supreme Court, which is since the decision in I'll try to make it short because you probably already know, but just in case. Since the decision in Windsor, 4 appeals courts have struck down state bans either on the recognition of a same-sex marriage that was legally performed somewhere else, or they've struck down the bans on whether a state has to issue a license to a same-sex couple to marry. So 4 appeals courts ruled that these kinds of bans were unconstitutional. The Supreme Court took a look at it last October and decided that they weren't going to get involved at that time because no court had ruled the other way. After that, the Sixth Circuit did rule the other way. It upheld restrictions in 4 states, the 4 states of that circuit, Kentucky, Tennessee, Michigan, and Ohio, and those will be the cases that the Supreme Court will be considering next week. 2 questions, I think they're up on the board right now as to what the court will be doing. It'll be having separate arguments on these 2 questions. Obviously, if the answer to the first is yes, then the second one doesn't really matter very much. So let me ask you one question about that, and I'll start with Steve. I think that you said when the court took this approach that you thought that this sort of offered an out for Justice Kennedy, that he could answer the second question, yes, states are required to recognize marriages performed elsewhere, and that this first question could be left for another day. Do you still think that's true?
I wrote something after the court announced the questions, speculating that there was that possibility. There was a lot of head scratching as to why the court divided it into these 2 separate questions. Now, law professors I respect have said, well, that's just because in some of the states at issue, it's about recognition. In some of the states, the issue is actually about licensing, and that's all this reflects. I do think there's a theoretical possibility that Justice Kennedy could see a sort of grand federalism compromise in the idea that no state may refuse to recognize another state's marriage, but that marriage must not be licensed. I'd say one other thing. I could see, this is just my own view, Justice Kennedy going along with that only if the first question were somehow held in abeyance, if the court could come up with some creative way to say we're going to dismiss the first question as improvidently granted. If the price of saying yes on the second question is to say no on the first question flatly, I have a harder time seeing Justice Kennedy going along with that.
Austin, what do you think?
It's
Can we
hard.
get an answer?
It's hard for me to see how the court could answer yes to the second question without the first question, because the second question is dependent upon the 14th Amendment. So what is the basis upon which another state would have to recognize? And if it's rooted in the 14th Amendment, that implicates the first question to begin with. And it's not a question about full faith and credit, which is important when we're talking about licenses and the impetus upon a state to recognize licenses and how well do licenses travel and whatnot. So I think that I think the first theory is correct, that so we have 4 cases before the court in the Sixth Circuit, and I know Ohio specifically, and I forget what the other one is really more of a recognition question. Tennessee, thank you, Steve. And then the others are really more licensing. So I think that the nature of the questions was to cover the nature of the cases before the court, but with one will go the other, however they choose to dissect it legally, if you will.
Okay. Robbie, during the oral arguments 2 years ago on Prop 8, Justice Sotomayor asked the lawyer, Ted Olson, who was arguing against Prop 8, that if marriage is simply between consulting adults, what's the limiting principle? Why can't it be any other sort of set of people who love each other and want to get married? Is there a slippery slope that you're proposing?
No, I don't think there is. What we're talking about here is treating people with equal dignity, that the Supreme Court has already said have equal dignity, i.e. your gay neighbors, your gay colleagues, your gay friends, the same as everyone else. There is not, and that is distinguishing and discriminating against people under these laws based on who they are and what their identity is. They're not allowing people to have polygamous marriages, or not allowing people to marry, God forbid, their brothers and their sisters, is not discriminating against people based on who they are. It's discriminating against people. First of all, there's not a huge swell of people who seek to marry their brothers and sisters, thank God, nor is there a huge group of people who are seeking to have polygamous marriages, thank God. But it's it's discrimination either based on the number of people you want to marry, or having I think, views about your own sexuality that most people would feel are uncomfortable and out of the mainstream. That's not true about gay people. It's discrimination based on who people are. And so the limiting principles and the interest that the state would have in limiting those marriages are very different. No one is arguing on any side of these cases that there's any harm to the children in these families to allow their parents to be married. To the contrary, all the states concede that it would be very good. It frankly would have been good for Heather. If, God forbid, Heather, who I feel a lot of pain for, quite frankly, I find that as a mother, I find it very sad. And I find what she says about her own mother to be very, very sad. I hope my son doesn't grow up to ever say anything like that about me, but it's hard being a parent. But she has said that her parents were very good parents and that the two women were very good mothers. If, God forbid, she had been, as a child, in a terrible accident at school with the non-biological mother, that mother might not have had access to her in the emergency room. That mother might not have been able to direct her attention if they couldn't get the biological mother to make decisions about what the emergency room doctors would have done to her. That's not good for any child. It's not good for Heather, and it's not good for any other child. So with respect to polygamy, incest, things like that, there are all kinds of good arguments. I don't need to get into them, that those are not good for children. It's not good for kids if your parents are brothers and sisters. It's not good for kids if your father has 85 wives. So it's a very different set of arguments.
Ryan, let me ask you another question that Justice Sotomayor asked. This one was to the other side. And it was, is there anything else that government can deny to a group of people, in this case gay people? Can they deny them jobs? Can they deny them certain benefits that government gives out? And if not, why can they deny them this?
Great question. So I want to affirm.
Well, it was from a justice of the Supreme Court.
It has to be a great
Should
question.
be pretty good, right?
I want to affirm the equal dignity of gays and lesbians. I know that this evening started by saying that people on one side of this debate are denying the equal dignity of gays and lesbians. So I just want to set that record clear that I imagine that everyone in this hall tonight affirms the equal dignity of gays and lesbians. And that's why I think the government shouldn't deny gays and lesbians anything. The question here is, what is the state's definition of marriage going to be, and whether or not marriage should be redefined to be changed as an institution to be more hospitable to what gays and lesbians are looking for. That's a very different question to say whether or not we should be denying gays and lesbians something that we're giving to everyone else, a job, health insurance, hospital visitation, things like that. So because I affirm the equal dignity of gays and lesbians, I don't think they should be denied anything like that. The question before the court, though, is whether or not the people should decide how to settle the very delicate and sensitive question of what to do about Heather, who has two mommies. And we've just heard two different policy solutions to that. Austin has a view about that. Robbie has a view about that. 9 Supreme Court justices don't have any greater insight into what policy will best serve the common good on this. Because there is the concern here that if you redefine marriage to make it a genderless institution, it will actually complicate someone like Heather's life. So Heather goes on in her amicus brief to say that other children who are raised in non-traditional families, whether it's through adoption, single parenting, divorce, if they express something's gone wrong and they feel trouble, they're validated in saying that. So the children of divorce, the children of adoption, the children of single parents, if they say, my life is tough right now, I'm missing out on a parent, they're validated in law and culture. Children who will be raised by same-sex couples where marriage has been redefined will be told, you're just like everyone else, there are no differences, and if you're experiencing a difference, the problem is with you, not with the family structure. So that's an argument on the other side. Again, I don't think the judges know which policy is going to come out best here, which is why we should allow the laboratories of democracy to figure this out. If Massachusetts and California choose to redefine marriage, they can see if that ends up being the best policy for all citizens. If the 4 states in the 6th Circuit want to say, wait, we want to see what happens if we retain the historic definition of marriage and we have other mechanisms for other parenting arrangements. The most common type of same-sex parenting in the United States isn't a lesbian relationship. It's a relationship between a middle-aged woman and her mother raising the child and the grandchild together. No one's suggesting we should redefine marriage to make that relationship a marriage, though. So there are other ways in policy that we can deal with parenting situations as they exist while affirming everyone's equal dignity without redefining marriage. Because the biggest challenge right now is that 40% of all children are born to single mothers. It's 50% of Hispanics and over 70% of African Americans born to single moms. If we as a culture want to insist that their fathers matter, how do we do that if the law redefines marriage to say their fathers are optional?
Okay, let me jump in. Steve, what about these laboratories of democracy? 37 states have offered same-sex marriage now. I think about 75% of Americans live in a state where same-sex marriage is available. But only 11 of those states did this come by a vote of the people or the legislature. The rest were imposed by the courts, either at the state or the federal level. Why is that a good way? Why does your side want to win that way?
Well, I think the problem is that the other side, the people who enacted these marriage bans, have left gays and lesbians and gay and lesbian couples no choice but to go to the courts. So the problem with the vast majority of the bans that exist, that have existed in same-sex marriage, including in the 4 states we're talking about now, is that they were constitutionalized. The last thing that the proponents of those amendments wanted was for the democratic debate and discussion to continue. They wanted to cut off the debate. They wanted to freeze the advantage they had when they had it, to be sure that a future legislature, a year or 2 or 5 or 10 years down the road, or a future plebiscite of the state's citizens, just majority rules like every other law, wouldn't be able to change the designation of marriage. These things are frozen in amber. They're frozen in concrete. Their whole point, the proponents told us, was to prevent the possible change in the definition of marriage down the road. So in the vast majority of these states, the democratic process, people talking and then coming to different conclusions, is actually not what the proponents of these amendments wanted. I would ask Ryan, if we could do away with all these amendments today, if we could do away with the referenda where the opponents of same-sex marriage like their chances because only 30 or 40% of the people who feel most passionately about the issue come out, and you've already blanketed the state with 6 months worth of ads about gathering storms and I am afraid and so forth. If we could just right now do a flash vote of the whole country or go state by state, same-sex marriage, yes or no, up or down, would you be willing to be bound by that? Because the last statistics I saw show between 54 and 58% of Americans supporting same-sex marriage, and even in the states that now ban it, the approval is 50%. So if we had a true representative vote of how people feel, I actually feel pretty good about the chances of how the American people would go along with this issue and not be bound by passions that were whipped up by Karl Rove in an election 10 years ago.
Austin, we don't vote on constitutional rights in this country. So why is this something that should be put up to a referendum?
Well, I have to disagree with the premise of your question. Okay. Obviously, that we're dealing with a constitutional right, and if we're going to talk about constitutional rights, we can't forget arguably the most precious constitutional right in this country, which is the right to vote. And one of the arguments being made by our opponents in these cases is that there is no constitutional right to vote on an age-old institution and its definition that impacts every single member of society. That right and the right to vote, whether it's at a ballot box or expressing your opinion through your elected representatives, should not exist. That this is inherently a constitutional question and the Supreme Court should take it away from everybody. And with all due respect to the professor, you can't have it both ways. It's either a constitutional issue or the polls matter. Polls and public opinion matter for the legislative process, not for courts. The Supreme Court's not going to decide this because 55% of the Americans, or whatever the statistics may be, they change every day, believe in or don't believe in same-sex marriage. That's a political question, which we think this is. So in that regard, polls should matter. And nobody's filing lawsuits saying when the citizens of New York, through their democratically elected representatives, chose to redefine marriage and engage in this social experiment, that was unconstitutional. As Ryan mentioned, we said the Constitution permits that type of thing. And what's interesting, if you notice in this debate, we're saying that both outcomes are permitted. That the Constitution is big enough and flexible enough for a pluralistic society that believes in fairness and tolerance in America, that both options are on the table. And what our opponents are saying is that, no, Your option that you prefer is not on the table, only ours. And we're going to take it by judicial force and quote polls at the same time and pretend like we're engaged in a political process. It's just a little bit of a, I think, logically schizophrenic approach there. And when the argument has not been made yet, or I haven't heard, maybe you'll give them an opportunity to get to it, Bob, as to why the Constitution compels the answer to this question.
You know, I'm going to do that. Robbie, why does the Constitution say that it has to be this way? There's nothing in it that says anything about marriage.
I agree with Ryan. I think the Constitution doesn't define marriage, which actually is a point on our side, not on their side. What the Constitution does say is that every American citizen is entitled to equal protection and due process of the law. And the court, time and time again over our history, has realized, this court, that older conceptions of who were entitled to that equal protection were wrong. When the 14th Amendment was passed, schools were segregated. It was perfectly okay, the founders, the people who wrote the 14th Amendment thought, to segregate black and white kids. And we all know that because of those words, equal protection of the law, that is unconstitutional. When the 14th Amendment was passed, it was perfectly okay for women not to be able to vote, for women not to have rights, for women to be treated like property in marriage. And we all know today that times blinded us to understanding that women are true and equal citizens with equal dignity like everyone else, and therefore that constitutional commandment, equal protection of the law, applies to them. And now we are at that point in our country's history with respect to gay people. We now know, or most people now know, that gay people too have equal dignity under the law, and that therefore that conception of equal protection of the law applies to them too. And while marriage has all these symbolic things which are important, marriage has enormous practical impact. It affects every single aspect of your life, from how much money you pay in taxes, to where you're buried, to how you raise your children, to what benefits you get from the government in terms of Social Security, et cetera. It's not just some symbolic thing. It has to do with equal protection of the law. That's why the Constitution requires, and I want to say one more thing. I fully respect Ryan, and when he says that believes that gay people have equal dignity, I accept that. But to tell teenage children of gay parents that what's wrong with them is that they have two mothers or two fathers, and that they should feel okay that that's what's wrong with them, poor mixed up teenage kids, given the overwhelming scientific consensus of every mainstream medical organization in the world that there is no difference in outcomes for children between having gay parents and straight parents. What matters is having two stable parents who love each other and who love their children. So for him to say that it's okay to tell those kids, your problem is that you have two moms or two dads, that's not respecting the equal dignity of gay people.
So Ryan, I'll let you answer that. And also, if you would, talk about, as you know, Justice Kennedy was quite concerned about children when he wrote the Windsor case. Judge Posner, in one of these cases, said it was particularly cruel to children of same-sex parents to deny them the right to legalize their union. So talk about that.
Sure. Let me venture another guess about the audience. I'm going to venture the guess that everyone in this hall is in favor of marriage equality, and we're all in favor of the equal protection of the laws applying to all people. We want to see all people treated equally. We want to see all marriages treated equally. Where we have a disagreement on this stage is about what type of consenting adult relationship is a marriage. We have two different visions of what marriage is. Our opponents think it's just about two consenting adults who choose to live with each other and love each other. Austin and I think the vision of marriage is about a comprehensive union of sexually complementary spouses where a man and a woman unite as husband and wife to then provide children with a mother and a father. We want the law to treat the vision of marriage that is true equally for all people. Marriage equality is based upon and premised on marriage reality. And what the Equal Protection Clause says is that you have to treat things that are the same in the same way. You don't have to treat different things in the same way. There are good reasons for thinking that the union of a man and a woman is different than the union of two men or two women. And so there are good reasons for the states to choose whether or not to recognize the union of two men or two women as the same thing as a marriage. The Constitution doesn't answer this. Equal protection alone won't get you there unless you smuggle in your own vision of marriage, the genderless vision of marriage, and then say the Constitution requires it. Because no one in this room wants to deny marriage equality to anyone, provided we understand accurately what marriage is. Robbie mentioned the studies on children raised by same-sex parents. Not a single one of the large random representative samples comes to the conclusion that she says all of the major scientific bodies now affirm. At the very beginning of this debate, Bob mentioned to us that this audience might not be random and representative. It's certainly not large. Large random representative samples matter. They matter for the audience of a debate. They matter even more importantly for social science. From a non-representative sample, you can draw no conclusions about a population as a whole. The only social science studies that have been conducted using large random and representative samples have shown that children raised by their intact married mother and father turn out the best on most every measurable outcome than children raised in all of the alternative parenting structures, including same-sex parenting. But even then, we only have 8 studies using large random representative samples on children raised by same-sex couples. So why would we want to rush to a conclusion one way or the other on this question when we have 8 studies? We have thousands of studies from the 60s, 70s, 80s, and 90s on parenting between a husband and a wife, a mother and a father, as compared to single parenting, divorce and remarriage, and cohabitation. So we had thousands of studies like that, and all of them came to the conclusion that the intact married family provided better outcomes than divorce and remarriage, cohabitation, or single parenting.
Well,
we now have 8 studies on the same-sex parenting question, so I just don't think the court should rush to a conclusion one way or the other. We should keep collecting the data. We should keep analyzing. We should keep debating.
Let me jump in and ask your side. Sometimes feel that you say it has to be one or the other. Why can't these two things coexist? I live in Maryland, and where same-sex marriage is legal, it doesn't seem to have made much difference there. Certainly in my life, or I think most people would not be able to tell you exactly when things changed in Maryland so that same-sex marriage became legal. It's not one or the other, so why can't they just simply coexist?
I'll take a stab at that. It's been 3 years in Maryland. What'll be interesting to see is what happens 30 years from now. What happens 60 years from now? What happens after a couple of generations? Because the law will either teach that marriage is about consenting adult romance and caregiving, where the consenting adults get to set the parameters on the size and shape of the relationship, or the law will teach that marriage is about a permanent, exclusive, monogamous union between man and woman, husband and wife, mother and father, because children deserve both a mother and a father. The law can't teach both at the same time. So the law will either shape the next generation of children, and then the marriages they form 20 years from now, and then the generation after that, and the marriages they form 50 years from now, in favor of the consenting adult romance view of marriage or in favor of the conjugal union vision of marriage. We don't know what that outcome will be, which is one reason to say, let the state of Maryland, you guys voted on this, you chose to redefine marriage. The people in Ohio, Tennessee, Kentucky, and Michigan voted on this. They chose not to redefine marriage. Let's see what happens 30 years from now. Let's see how it changes. The preliminary data suggests that states and nations that have redefined marriage, that keep data on this, have seen that their marriage rates have declined faster than what would have been the trend prior to the redefinition of marriage. Maybe that's just a historical blip. Some people are saying it's because of the recession. Who knows? Why rush to constitutionalize a decision through the Supreme Court when we don't have all of the evidence in?
Yeah, what's the rush?
The answer is we know what's going to happen. What's going to happen is nothing. And Ryan knows as well as I do what the statistics are in Massachusetts, which is the state that's had marriage for the longest, over 10 years. Divorce rates in Massachusetts have gone down since marriage equality was instituted in Massachusetts. He knows that as well as I do. He can keep pulling numbers out of his hat, but that's the truth. Divorce rates have gone down in Massachusetts as well. They have not gone up as a result.
Okay, you'll get your turn.
And the truth of the matter is, we know what's going to happen. What's going to happen is nothing. What's going to happen is that people and children and families are going to be able to be raised and be treated with the equal dignity of everyone else. And what's incredible in listening to this is that what should have been said to the Lovings? Should the Lovings in Virginia have been told, we don't know what the impact is going to be on your children to have a black father and a white mother, or a black mother and a white father. Let's do 30 years of studies.
But we did know.
Please don't interrupt me. Let's see what those 30 years of studies do for interracial marriages. Let's see what 40 years of studies do for desegregation in the schools before we let black kids go to school with white kids. That's not how the great Constitution that this great country should be so proud of operates. Justice Jackson and Barnett, the judges of this great Supreme Court, know that we don't tell Americans that they have to wait 30, 40, 50 years to be treated the same as everyone else. That's not how our system works. That's not how it has ever worked in the past. That's one of the great strengths of this country. And that's not how it should work for gay people.
Okay, it's your turn. Hold on, not yet. My God. Everybody calm down. There's plenty of time. Now, we would like for you to speak into a microphone. If you wait your turn for a microphone to come to you, you'll be the first audience in history that has ever done that. So let's go for the world record here. And so please make your question as brief as you can, so that these guys will all have time to answer it. And we'll start with you.
Hi, this is a question for both sides. You indicated that a state could not be constitutionally compelled to recognize a marriage between siblings or a parent and a child. And I think we'd all agree that a state would not be constitutionally permitted to regulate marriage on the basis of comparative shoe size. I think there's probably an area in the middle where there's some room for flexibility. There's a line where states are compelled to recognize marriage, and there's a line where certain things are just considered irrelevant. How do you find those two lines?
Well,
what are the metrics you use to find those lines?
I assume, sir, that you have gay couples who are your friends? You have gay couples who live down your street who are your friends and neighbors? Do you think that their relationship is the same as the shoe size? That the love and commitment that they have for each other is the equivalent to what shoe size people wear? Or that the love and commitment and the way that they live their lives is the same as a man who has 85 wives? It's not the same thing. Being gay is not the same as a shoe size. Being gay is an identity of who people are.
Right, no, I'm asking a legal question that has to do with constitutionality and where you draw the lines on a legal basis. I'm not asking about policy questions. So that's what I'm trying to get at, is on what constitutional basis?
Yeah,
according to precedents or to legal lines, where do you draw those lines?
That is the constitutional basis. The Constitution, the Supreme Court has said in Windsor that gay people have equal dignity. Once people have equal dignity, under the Equal Protection Clause, they have to be treated the same unless there's an incredibly good reason to do so. Treating people, excuse me? There is a very good reason to what? Not let brothers do what?
Marry. He's saying, what's a court going to say as to why these two people can't get married?
Because you're not treating two brothers who want to get married. There's not a class of people who are brothers who want to get married to each other. There are a class of gay people in this country who live their lives as openly gay people who want to be treated the same. There is no.
Okay. Let's let them debate, and you ask the question.
Oh, I want to respond first to the dignity point that Robbie has brought up. And remember that there's more dignity at stake than just out of same-sex couples. And remind the audience of the story of Heather Barwick. And we think about the dignity of kids. What do we owe society? What do we as a society owe children? And do we have a right to make decisions for children to intentionally deprive a child of a mother or a father? And if we do, from where comes that moral right? Or does every child have an inherent right to know who they are from where they've come, and then we as a society have an obligation to honor that right, and to maximize the possibility that that child will be known, loved, and raised by the mother and father that brought them into this world. Now, that is a question that is inherently, goes straight to the heart of the dignity of human beings and who we are, because every one of us has an inherent desire to know who we are and from where we've come. And that cannot be left out of the equation. Sir, to your question about where do you draw the lines, the states have drawn the lines in different places on marriage for a long time. For example, I think there are 18 states that allow first cousins to marry. My numbers may be off, for example. The rest of the states, it has to be second cousins or greater level of consanguinity. New Hampshire, I think with parental consent, if you're a female, you can get married as young as 13. Other states, it's kind of 18, and there's no exception. The states have tinkered with that. And so there are permissible lines, I think, within the Windsor opinion that the Supreme Court acknowledges where the states do different things according to policy. But one thing is consistent about all the requirements to get married: age, consanguinity, sex. They all go to one core thing, and that is because children are expected to come out of that. Why do we make you wait to get married? Because we can't have children raising children. Okay? We need somebody who's an adult, who's finished school and is able to provide for a child. That's why we have an age restriction. Why do we have consanguinity restriction? Why do we limit it by blood? Because we don't want families procreating within families. The dynamic there is destructive. And why is it opposite sex? It's because men and women procreate. Not one single marriage license application in this country, I'll finish with this, even in the states that have redefined marriage, the 11 states that have done it, ask anybody for their sexual orientation when you go to get a marriage license. You only are required to identify your sex, and there's a very good reason.
Okay, I'm not doing a very good job of moving this along, so I'm going to be much tougher. Yes, ma'am.
Hi, I have a couple of comments.
Let's make it a question, okay?
A question,
please?
okay. If marriage is indeed between a man and a woman for procreation, then why don't states require fertility testing?
Thank you. Good short question. Love that. Bam. Go.
And I think the professor could probably answer this, because we also recognize the privacy individuals, and there's a case called Griswold versus Connecticut, I think would pretty much establish that there's no way we would require fertility testing under any set of circumstances whatsoever. So what's the starting point for marriage law? The starting point for marriage law, and you can get these statistics from the CDC, 99% of the kids born in this country are the products of good old-fashioned heterosexual sex. And when you're a state legislature and you're legislating, you legislate on the rule, not the exception. Okay? If we legislate on the exception, then that means because somebody commits Medicare fraud, we'll just eliminate all Medicare benefits for the good people. That doesn't make sense. We legislate on the rule, not the exception, and no law always fits perfectly. Okay. But when we recognize that, that's why we have marriage laws, and that's the basis of it.
Okay, Steve, I bet you have something to say about that.
Yeah, I think, I mean, in effect, this is what our friends on the other side would impose, a fertility test. They have taken the fact that a man is born with a penis and a woman is born with a vagina, they've taken coitus and made that the irreducible requirement and essence of marriage. No, the essence of marriage is, if it's about children, it's about raising children. It's about teaching children. It's about nurturing children. It is not about the biological mechanism of how children are brought into the world. The court said in Smith versus Organization for Foster Families, it's the importance of the familial relationship to the individuals involved as well as to society stems from the emotional attachments that derive from the intimacy of daily association and from the role it plays in promoting a way of life through the instruction of children. And I would note, I still haven't gotten an answer to my question. What about the 400,000 children in foster care? What about the 101,000 children awaiting adoption? We know that gay and lesbian couples disproportionately adopt those sorts of at-risk, at-need children who don't have parents, who don't have the choice for for a mother or a father and give them nurturing homes. I don't understand logically how we're supposed to deal with the Heather situation unless we're going to compel gay men to start marrying women to serve as fathers. Holmes may have said the life of the law is not logic, it's experience, but I don't understand the logic of how denying same-sex marriage to couples who are going to be having children anyway, through artificial insemination, through adoption, through other means, I don't understand how that will provide more fathers for children like Heather. It simply won't. We're
Okay.
talking about two different issues.
All right, thank you. Yes, sir.
Yes, I guess I would frame the question a little bit differently. Why can't states regulate behavior like they always do? Statistics show that a man has a great impact on a young boy. A man has a great impact on a young woman. Vice versa with the woman. A man and woman bring different things to the table. A child benefits from that. That's a rational basis of regulating the behavior and encouraging certain behavior that will help the child grow. Being black is immutable characteristics. Studies show that being gay is not.
Okay.
There's also studies that show that there's an adverse impact. I think American Family Association published a study by Regeneris that suggested that kids of gay couples do suffer more abuse, that they have more emotional, mental, and other problems. So that why can't the state regulate a behavior that it has an interest in doing? And
Okay, let him
benefiting the
answer your
kid?
question.
Yeah, I'm
Okay.
glad you brought up Mark Regeneris because Mark Regeneris' work, he's a sociologist, has been at the center of a lot of defenses of marriage bans. Mark Regeneris' work has been thoroughly and categorically repudiated by his own professional colleagues, the American Sociological Association. I'll give you just one example why. In his study, he compared intact man-woman marital families, and his test group on the opposite side was a person who had ever had any sort of same-sex contact in his or her life at any time. So he didn't compare apples to apples. He didn't compare intact married opposite-sex couples with intact married gay couples. This is an example of the kind of pseudoscience that passes for evidence in these cases. I'm sorry to point this out, but in Ryan's book, he cites a study from 12 years ago that now appears on the web and says this study should not be cited or used. It doesn't really prove anything. It was done at a time when the numbers were too small. No valid conclusions can be drawn from this study. I'm sorry, I choose to believe the American Psychological Association, the American Sociological Association, all these other credible peer review-oriented academic groups about what the research really shows about the welfare of children and families.
Ryan, well, let me let Ryan respond to that since he was called out. Ryan, but the AMA today did, I think, have an editorial
Yep, I saw that.
urging the court to agree that there should be same-sex marriage, saying that it would be helpful to those families.
Yep.
So.
So I don't know where the American Medical Association got its law degree or what makes them experts on constitutional law. It looks from the audience here, most of you attended college. You would not be surprised to learn that professors can be politically motivated and that there's lots of ideology in the academy. So it's not surprising that the professional associations reacted violently when there was one study that came out that challenged the unanimous conclusion that they had doctored up. The peer-reviewed study that Mark Regeneris did was published. They then issued a giant protest about it. The peer review process and his department stood by him. They opened a scientific misconduct charge against him at UT Austin. He was cleared of all scientific misconduct. When his study was published, someone in favor of same-sex marriage, the dean of social science on family studies, Paul Amato at Penn State, said this was the best study that we had to date. Of course, he acknowledged that no study is perfect. He said it was the best one so far. I want to answer the question that you answered, though. It seems to me that there are three ways to think about what you said. Of course, the states can regulate behavior. And this is what distinguishes, first, this case from the interracial marriage case. Were there any good reasons whatsoever to think that marriage had anything to do with race at all? And the answer is no. And historically, marriage had nothing to do with race. The reason that we had bans on interracial marriage in the United States is because of our unjust system of race-based slavery. It was because of bigotry. It had nothing to do with marriage. Interracial couples had been raising children all throughout human history. We didn't have to wait for the science to come in, as Robbie suggested. We knew that it was possible for a black man and a white woman to unite in the marital act and create new life, and then to unite that new life with their mother and their father. And that's why every great thinker throughout human history said that marriage had to be colorblind, but it couldn't be genderblind. You look through Aristotle and Plato, look through Augustine, Aquinas, Luther, Calvin, Locke, and Kant. They all thought race was irrelevant to what marriage is, because like you said, it's not a behavior, it's not an action, it's an immutable characteristic. They all thought sexual complementarity and the union of a man and a woman uniting in marriage, that went to the heart of what marriage is, precisely because it can create new life and then unite a child with that new life.
Okay,
so the
Ryan,
second way,
Ryan,
the
can I
second
ask
thing here
a-
is real
can I
quick,
get
because
another
someone else had
question?
mentioned this, on the artificial insemination. This is precisely the point. If you redefine marriage, you make it more likely that more same-sex couples create more children to then deny them a union with either a mother or a father. You change the definition of marriage, you change the definition of parenting, and then technologies like artificial insemination, which was already mentioned, will be more greatly utilized, creating more children to then be denied from the very moment of conception a relationship with a mother or a father. These are behaviors. and
Okay,
it's
Ryan,
perfectly
the crowd's
rational for a
turning
state.
against you because they want to ask more questions.
Let me say
Yes,
one thing.
sir.
I
And
want to
just,
say one thing. Sir, states can regulate behavior, and they should. And the kind of behavior they should be regulating are people who have the view that young gay boys can change being gay and should go to therapy to try to change that, because what happens from that therapy is they kill themselves.
That's
In
not
record-
true, ma'am.
in
Okay,
record
okay,
numbers
I'm gonna go
throughout our
back
country.
here.
Just one thing.
No more. Sorry.
We're still one
being
nation under
rough.
God.
I'm being rough here.
One nation
This
under
is what
God.
Professor Sanders, you repeatedly raised the issue of adoption. It would appear in the ensuing months and years after Massachusetts that the largest adoption provider in that state, the Catholic Church, got out of that business. My question to you is how, and I'm going to put this to both sides, how do you best reconcile religious liberties and civil liberties? And then to the other side, for same-sex couples seeking to adopt, how do you reconcile religious and civil liberties?
I think we reconcile religious and civil liberties by recognizing that we're talking about a civil definition of marriage. We're talking about a marriage license given out by the government. The First Amendment already protects churches and pastors. It's a canard, it's a red herring that churches and religious denominations are going to be forced to perform same-sex marriage or to welcome same-sex couples into their churches. They won't. We're talking about a civil institution of marriage. The issue of anti-discrimination laws, of whether you are allowed to discriminate on the basis of sexual orientation, is a different issue. Those have been democratically adopted by cities and states through the legislative process that we like so much. And in those jurisdictions, elected officials have come to the conclusion that discrimination on the basis of sexual orientation is a social evil, is a social problem, in the same way as polluting the environment or not paying your taxes. It's a regulation that you have to abide by. I don't know exactly why Catholic Charities decided to stop doing adoptions. It sounds, from what I know of, it was their form of protest against the idea that they might have to serve legally married gay couples. I'm sorry for the sake of the children involved that they decided to do that they thought that this religious principle of theirs was more important than placing more children in stable two-parent married households.
Austin?
Let me address the adoption and foster care question, because that's been brought up a couple times. The state's interest in adoption and foster care is dramatically different from marriage. The approach is two completely different things. Every child who's a ward of the state has had their relationship with the mother and father that brought them into this world severed. That's happened, okay? They're a ward of the state. And so the policy then is, how do we rally around this child and try to give them something that they don't have anymore? And so when we're approaching adoptions, the state can approach it many ways. So it's a second best dynamic, right? Some states say, we want to give this child what they're missing out on, a mother and a father. Other states, a lot of other states will do a lot of single adoptions, and then some states have expressly adopted same-sex couples as multiple options to cultivate a secondary dynamic for a child who's a ward of the state. And I think that there can be reasonable debates about all of those options, both good and bad, and we can talk about all of that. That doesn't translate to marriage. Because the quintessential question on marriage is whether we are going to intentionally at the outset, by design, deprive a child of a mother and a father or sever that tie. And so I think there's two different policy approaches, and you can't just throw them in the same thing and shake them up and say, oh, it all comes out the same way, because that doesn't really happen.
Except I think what he asked, and maybe I'm wrong, but would it be better for a child not to be adopted than to go to a home with two gay parents?
I think that's a reasonable question. Well,
What's the answer?
And I think, well, it depends on the state. Like, I know, for example, in Virginia, the foster care numbers are extremely low. I mean, they've been very successful getting kids out. There may be other states where you have high volumes of foster care kids or kids sitting in orphanages or something like that, and you're balancing, is it better for this child to sit in an orphanage, or is it better to put them with a same-sex couple? I can see reasonable answers both ways to that, but it doesn't enlighten the marriage question. And that's really the most important thing as it pertains to this debate. I'll briefly touch on the religious liberty question that was addressed. What happened with Catholic Charities is the state was unable to make an accommodation for them to function within their religious beliefs. And the intolerance for religious beliefs is a growing theme in this country. There are lots of adoption service providers in Massachusetts that would provide kids out to same-sex couples. So why is there no room for an Orthodox Christian adoption service provider that wants to do the same thing and help these orphans consistent with their religious beliefs? That doesn't make a lot of sense. And I could go through a lot of cases, I'm not going to, that we're litigating where that theme is repeating, and it's a problem.
All right, I'm going to move on. Yes, sir.
Hello. My question is for the I guess the proverbial pro-gay marriage side. Bringing us back to the topic of whether or not the 14th Amendment does or does not mandate states to recognize a same-sex marriage on the basis of equal protection under the law and the due process clause. And since our question in the 14th Amendment goes to the second one, might as well take that one out as well. At the time of the adoption of the 14th Amendment, 32 of the 37 states in the Union had criminal sodomy laws. 4 of those states went so far as some today might say quite extreme, saying, it even punished it by death, and 11 of them punished it by a maximum penalty of life imprisonment. With that in mind, how could it possibly have been the original intent of the 14th Amendment to bless a same-sex union? I'm not,
Okay, we got it.
Okay,
They're ready for you, I can tell you that.
I actually think that point helps us rather than hurts us. At the same time, at the time of the adoption of the 14th Amendment, there was virtually uniform segregation in the public schools. There were no black children anywhere in the country who went to school with white children, and it wasn't until 1953 and 1954 that the Supreme Court held that even though the people at the time did not believe, they believed in separate but equal. That was the law of the land at the time of the 14th Amendment under Plessy.
Thanks to the court, yes.
That under the very broad, intentionally very broad language of the 14th Amendment, that there need to be desegregation. The 14th Amendment, unlike frankly other amendments, was deliberately written to be broad. It was deliberately written to deal with changing times. That's exactly what Brown v. Board stands for. And the exact same principles apply here with respect to gay people. People didn't realize in the 1860s that it was the right and proper and good thing for black children to go to school with white children. And people then didn't realize that gay people should be able to have the full dignity of their lives and not be put in jail for being gay.
Okay.
Now people realize that.
Do you guys want to say anything, or do you want me to get another question? Another question. Yes, sir. Hurry with that microphone. We're running out of time.
Yeah, for Ms. Kaplan, one of the things that you expressly repudiated was plural marriage earlier. And when you look at the idea, if I had 2 wives, we could raise children very well. We could even adopt some of the 400,000 that Steve has talked about here. In effect, you've replaced my definition of marriage with your definition of marriage in a capricious way. Why is that inaccurate, and why do you not allow for plural marriage And your arguments also bless that.
Well, actually, all the studies that have been done on plural marriage show that they're very, very harmful to the women and the children in those marriages. That's just what the studies show. They are very often very abusive to the children and very abusive to the multiple wives. It's often, usually, I'm not aware of any plural marriages with multiple husbands. Maybe if there were some, it would be different. But they're all multiple wife situations, and unfortunately and sadly, there's a high rate of both poverty and abuse. There is no one, not one of the states, in any of the cases before the Supreme Court who is making that argument about gay families, because it's not true. So that's one of the very main differences between those two kinds of sets of marriages.
Okay, I can't imagine a woman who would want two husbands, but do you guys want to say something
I want to say
on
one
this
thing in
side?
response to that, because it strikes me that if there's a fundamental right to marry, and if marriage is about consenting adult romance and caregiving, why are you denying the fundamental right to marry for people who want to have a marriage that looks slightly different than yours? Why are you denying the questioner his fundamental right to marry the two people he loves? Or you said you didn't know of any multiple husband situations. I'm surprised you say that, because there are over 500,000 polyamorous households in the United States, many of which are multiple male partnerships. So New York Magazine highlighted a throuple, 3 men who live with each other, love each other. It's not polygamous, it's polyamorous. On what basis do you deny them their marriage equality? If you go to the Supreme Court and you sue for the same-sex couple, why do you deny marriage equality to the same-sex throuple? The way that we got at monogamy was that it's one man and one woman who can unite in the marital act that can create new life. Every new life has one mother and one father. If you say male-female is irrational, arbitrary, and bigoted, what's magical about twosomes?
Okay.
And why can't 3 people have a consenting adult loving relationship?
Carrie, can I take one more question? Okay. Yes, ma'am.
Hi, my name is Saba Ahmed. I wanted to ask a question about the fact that the whole Islamic world has plural marriages. They have not had, I'm sure there's multiple studies about, and I personally don't agree with the polygamy situation, but I think it rises to the same question that if 2 adults or 3 adults or 4 or 5 adults are allowed to, one man can have 4 wives, then what's wrong with that? And why is that not illegal in the United States?
Okay. Here's how I think the Constitution thinks about this, or constitutional scholars and hopefully Supreme Court justices think about this. Slippery slope arguments are the crutch of those who want to escape hard thinking, of actual analysis, reasoning, and line drawing, of the lawyer's arts of analogizing and distinguishing. The logical stopping point is what society understands marriage to be, not 100 years ago, not 50 years ago, not 10 years ago. Today, we begin from the principle that marriage is a fundamental right, because the Supreme Court has said that. Then we shift the burden to the government to put it to its proof, to say, what is the objective harm that will come from ending this exclusion, from ending the denial of this group? What we're saying is society has, by all accounts, by public opinion polls, by scientific data, arrived at the conclusion that same-sex couples are able to fulfill our lived understanding of marriage. The common law method of constitutional decision-making goes one case at a time. It may be that 10 or 20 or 50 years ago, our society will get to the point where it embraces the idea of plural marriage, but it's a debating trick, not legal reasoning, to say that inevitably, because you're allowing same-sex couples to marry, you have to allow other people to marry. No one is purporting to define marriage, no one at this table is purporting to define marriage as genderless, as anything that 2 consenting adults wants to do. American society has become very comfortable and very understanding of what it means for a gay or a lesbian couple to want to marry. That's the problem, that's the issue that's in front of us, that's the issue that's in front of the Supreme Court right now. Other forms of marriage, other forms of exclusion will have their day in court. They will have their Loving versus Virginia, or their Windsor, or their Lawrence, or their Romer. We haven't had that yet with plural marriage. We have had those decisions with gay people.
Okay, I'm going to
Can I
do
say
one
something in
more. I'm going
response
to
to
do
that?
one more. No, you've already responded to it.
He was responding to my point on that. Each side gets a response to the question here. And what
Do you want to hear him, or do you want to hear another question?
I want to respond to the attack. He just very clearly said that what I was doing was a debater's point, not legal reasoning. Now, I'm not a lawyer, and I'm not a law professor, but I don't have the arrogance to say that Justice Sotomayor wasn't engaging in legal reasoning when she asked Ted Olson what his limiting principle was. Legal reasoning asks, what is the principle that you're operating on, and what is the limiting principle? Nor do I have the arrogance to say that the Sixth Circuit Court, when it explained why it was upholding the definition of marriage as the union of a man and a woman, was engaging in a debater's trick, not legal reasoning, when it explained why they weren't striking down those laws. They said the plaintiffs had a vision of marriage, they had a definition of marriage, and that this is what they were trying to say the Constitution requires. This is what the majority of the Sixth Circuit then said in their opinion. Their definition does too little because it fails to account for plural marriages where there is no reason to think that 3 or 4 adults, whether gay, bisexual, or straight, lack the capacity to share love, affection, and commitment, or for that matter, lack the capacity to be capable and more plentiful parents to boot. The Sixth Circuit then concluded if it's constitutionally irrational to stand by the man-woman definition of marriage, it must be constitutionally irrational to stand by the monogamous definition of marriage. Plaintiffs have no answer to that point, end quote.
Okay.
That's not a debater's
All right,
point.
Ryan, we
That's
have to
not
stop.
rhetoric. That's legal reasoning.
Okay,
And
Ryan
it's
ran up. I'm sorry. Yes. That lady in the back. Yes.
Thank you. I have a question, and I'd like to make a point first. I just lost a dear friend who died of AIDS. I watched him go through therapy. It wasn't coercive, nothing. I've seen many of my gay friends actually come out of a gay lifestyle, just to make a point. My question has to do with, I haven't heard anyone bring up that most of the faiths that exist in our country do not believe in same-sex relationships, and also who was the creator, the original creator of sex, who did the founders think was the creator of marriage or sex? Why is that not part of the conversation? And also, might there have been, from when the founders were created and today, with all the media and all the desensitizing that we see on the TV? For example, we have a show called Mistresses about adultery. Well, there are a lot of people out there whose lives have been ruined, but
Okay.
that now it's a big show.
I know your point. So I'm going to this is how we're going to end it. Each of you talk about whether religion should play some sort of role in the court's decision. How about that?
Okay, let me say.
Well, we'll go this way. Ryan, you can.
Sure. I don't make a religious argument about this. The perspective that me and my co-authors come from is one informed by philosophy. It looks to Aristotle as not saying this is what he thought, therefore it's right, but he gave us a methodology for how to think about institutions. He gave us an insight on how to analyze institutions. He told us look at the actions that they engage in, look at the goods that they're ordered towards, and look at the norms, the commitments that they make to each other. We thought what makes the marital commitment different than other sorts of commitment, what makes the marital relationship different than other commitments, precisely through that tripartite lens. Look at the acts that they engage in, the goods that they pursue, and then the norms that they commit by. So it's purely a philosophical view. We think our philosophical view is a plausible one. We happen to think it's the true one. We think our opponent's philosophical view is plausible. We happen to think it's a false one at the end of the day. We don't think our Constitution requires either. We don't think our Constitution forbids either. We think this is a discussion for citizens to be thinking through these issues and then voting on.
Okay, Austin, religion?
Yeah, I think religion does play a role to the extent that we're dealing with the question of animus and whether marriage laws are the product of unconstitutional animus towards gays and lesbians. And so where religion comes in is one of the key cornerstones of animus has to do with whether a law is novel. So when you look at the law in the Romer case or federal doma, it's something that had never before been done. The Supreme Court kind of characterized it in some respect as a coming out of left field. Congress had never before defined marriage, and this is new. Why are they doing it? We have to find out. It's animus. Okay, you can't make that argument about marriage laws. You just can't. They existed before this country existed. Okay, like in Virginia became a colony in 1607. It was one man and one woman before the idea of same-sex marriage even popped into somebody's brain. So the religious traditions and the history of marriage and the existence of these marriage laws throughout all these religious traditions and cultures and everything that inform the melting pot that becomes America absolutely wipes out the idea that marriage laws are new and therefore unconstitutional animus. And I think to that end, in terms of this constitutional debate, that's where they are significant.
Okay, thank you, Austin. Steve?
Actually, at least one of the states in this litigation, Kentucky, actually had no definition of marriage up until the time the idea of same-sex marriage came around. And then, in this sort of hair-on-fire backlash of the mid-90s and beyond over the possibility of same-sex marriage, they passed a statute, then a constitutional amendment prohibiting the legislature, prohibiting the state courts, prohibiting a majority of the state's citizens from being able to ever change the definition of marriage. Those categorical, impossible to change constitutional amendments are what's been unusual. But to address briefly the question of religion, I think the audience member's point would come as a surprise to Episcopalians, Presbyterians, members of the Disciples of Christ, members of conservative Judaism, members of Reform Judaism, all of whom have embraced marriage. And finally, I think we need to remember the state judge that sent Mildred and Richard Loving to prison after they got an interracial marriage said, God created the races white, Malay, yellow, and red, and white, black, Malay, and red, and but for interference with and placed them on separate continents, and but for interference with his plan, we wouldn't need to be here. We need to separate out religious conceptions, as valid and as vital and as wonderful as they are, those traditions, those ceremonies, those beliefs, from our civil law and what the Constitution says about who may be excluded from public benefits and public civil institutions.
Okay, Robbie?
First of all, let me say that I live in the heart of Greenwich Village. So I live in the den of the den. And despite what Ryan said, we have in my building and in my neighborhood lots of gay couples raising kids, lots of straight couples raising kids, lots of older single parents without kids, etc. I'm not aware of any polyamorous families living anywhere in my neighborhood in Greenwich Village. So again, I think it's really, it's one of these things that people say to scare people, but there's no organized political movement of polyamorous people out there. And if there were, they'd be in the village, and I don't see them every day. As for the separation, or the religious point, I'm a deeply religious person. And I believe in the Hebrew Bible and the rabbinic tradition, and consistent with my view of conservative Judaism, says that each human being is made in the divine image, and that affording full dignity to every person is a religious obligation, and that we are commanded as religious people to pursue social justice. It arises from the biblical injunction that it is not good for a person to be alone, and that the opportunity to create a family is an essential aspect of our humanity and our obligation to express as fully as possible the image of God reflected within every person. So what that means, I think, is that different religious people have different views on this. We can respect different religious people's different views on this, and that's the genius of our Constitution, because that's why we have a First Amendment in this country, and that's why we respect religious pluralism, and that's why these issues need to be decided on constitutional principles and not based on religious belief. Thank you.
Okay, well, thank you. And thanks to all of you for your attention. And people often ask me as a reporter, isn't it hard to, tell both sides? Isn't it hard to stay in the middle, stay objective? You see what I live with every day. I have people on both sides yelling at me, and so it's really not very hard at all. So thank you for your attention.